Good morning. We're dealing today with topic 10, physical maintenance or physical management, part 2 of the training schedule. We have Dylan Yersop from DTB Attorneys with us today. Dylan, welcome. Dylan is a sectional title attorney, a well-known sectional title attorney, and we thank him for assisting us on this topic. So welcome, Dylan. Let's get going. I think when we look at physical management, I think it's important that we look at maintenance and improvements, what maintenance is, what is improvements in general, improvements of common property, I think improvements in respect of sections, improvement of exclusive use areas. And then I think we can also look, and I think the module then looks at prepaid and postpaid meters and so forth. So I think that's in general what we cover in the topic, if I remember correctly. I wonder if you want to take us maybe and just have a little bit of a chat about maintenance and improvements.
Hi, Willie. Thank you very much for being a part of this. We're really appreciative of being here. As always, I really enjoy Stratafin's attempts to try and educate the masses. It's definitely a wonderful platform. I think from a physical management perspective, it's important that we understand the differences between maintenance and improvements. In layman's terms, and I mean, you guys took a lot of effort to compile these manuals, but maintenance strives to keep the common property in its original state of appearance. So that is more remedial work. We've got cracked tiles, we're sorting that out, or something of that nature, where an improvement, and I mean, I always say most improvements, one can see that the economic value of the scheme may increase, and that could be a determining factor as to decide whether it's actual maintenance or improvements. But I mean, some things that can include improvements is as well painting the scheme a different color, perhaps installing generators. We all know the power suppliers are amazing at this point, so these types of things can be seen as improvements. So I think in rudimentary terms, that would be the differences between maintenance and improvements then.
Can I just jump in there? What we see in practice happens a lot is that people include in their 10-year maintenance plan under the guise of maintenance improvements of the scheme. So we must be very careful that that is not being done, because obviously, as we're going to discuss now, there's a different way of approving maintenance and a different way of approving improvements. And by just throwing it as part of the 10-year maintenance plan, one then does not necessarily will be going through the correct improvement process by the Act, and as such, it would not have been approved by the members.
Absolutely.
Yeah. So sorry that I interrupted you.
No worries. So I think a guiding or start point could be improvements to common property. That's something we have to zoom in. And this is now where you've dealt with this distinction. I mean, unfortunately, the 10-year maintenance plan deals with repair, upkeep, maintenance. It doesn't deal with improvement. So you're quite right in that. So when one looks at improvements, and I mean, from Tukas Sada, if I can call it like that, the distinction was luxurious and non-luxurious improvements. But with the advent of the new legislation and the STSMA, we have the distinction reasonably necessary or not reasonably necessary. That's where we'll start our determination in relation to how we would go about to undertake these improvements to the common property. I think Prescribed Management Rule 29 provides a lot of guidance to schemes so that they can now actually understand how one should go about when dealing with these improvements. It's always important, and sometimes I feel like when we read the Act, one should read it lopsided in a few times, and this is one of the cases where Prescribed Management Rule 29.2 would probably have to be read first before we read Prescribed Management Rule 29.1. But this deals with whether it's reasonably necessary, and the Act says, and again, it's quite encapsulated in the study material, but I think it's important that I read it. The body corporate may propose to make alterations or improvements to common property that are reasonably necessary, provided that no such proposal may be implemented until all members are given at least 30 days written notice. And then also, I mean, whether it stands here or not, with any type of notice, it's always important to provide all of the material information. How are we going to do it? What are we going to do? Where are we intending to do it? I mean, with an improvement, it would suggest perhaps that the plans would be affected, which means now we need drawings and stuff like that, so that we can actually now ensure that the members are provided with sufficient notice. Then
What would you
after
think? What would you think is reasonably necessary? What is let's just deal with the term reasonably necessary, because I think that's important as well. Eh?
Yeah, so I think from the start it's very subjective. So it's unfortunately there's no silver bullet which deals with this is necessary or this is not necessary. But it depends on the needs of the scheme. I mean, we've dealt with schemes in Camps Bay where they've said, you know what, our neighbors have 3 pools and we've got 2 pools, and now we want to install a 3rd pool because, you know, it's a status type of thing. So there we've seen it's reasonably necessary. But to my mind, it would be what is reasonably necessary for this group or quorum of owners that we have. Perhaps taking it to a vote, that could be a good suggestion, asking the members, do you guys think it's reasonably necessary? I mean, we all know with any decision where trustees want to avoid liability or accountability, they take it to a vote. So it's quite difficult to say what is reasonably necessary, but I think it depends on the means of all of the owners in the scheme and also what they want. But again, it's a subjective test, so it will depend on each and every matter. Yeah,
the big question that we're currently facing, and we see that in the industry a lot, is about solar. So would one be able to say that installing solar in the scheme is reasonably necessary, or is it not reasonably necessary? Taking into consideration the problems that we currently have in South Africa with electricity production.
Yeah, so I think important to that is the selling point that these power suppliers give, which is that we are actually going to sell you power cheaper than COJ. If that is the intent, then it's not necessarily reasonably necessary, because we're not trying to now alleviate the power supply problem. We're actually trying to get solar installations that are cheaper, or trying to beat our municipality at our rate. So from that perspective, it would not be. So I think it would all depend on the intentions of the particular scheme. Are we trying to now alleviate our struggling power supply, trying to make it easier on the grid or whatever? Or are we actually just trying to save a buck? Because if we're trying to save a buck, I don't think that is necessarily reasonably necessary in my view.
And if one look at that, and for example, you look at a power purchase agreement without batteries, because that's something that you're now actually touching on, where we're trying to reduce the price of electricity by having a power purchase agreement in place, and that will be cheaper for the scheme, and they will get their electricity at a smaller cost. Then the question is, are we looking at what is reasonably necessary for owners? Because if you want to alleviate the problems of load shedding, and you're only going to produce power during the day and you don't have batteries, then are you actually looking at the real problem?
No, absolutely, Billy. And again, now the body corporate is taking up to try and become a power supplier, or trying to get someone to be a power supplier. And I mean, we're already faced with people just trying to ask people to pay levies. Now we actually incurring further liability, where we're actually now believing that all of our members would now be in a position to contribute towards this. So, yeah, to me, it sounds like a very, very difficult question.
So under those circumstances, I would not think that one would be able to make the argument that it was reasonably necessary. So it would then fall under the 29(1) portion of Prescribed Management Rule 29 of improvements that is not reasonably necessary.
Yeah, no, exactly that. But I think just to track back to the part here, so now we've decided, yes, it's reasonably necessary, whatever that may be. We've now given our members this notice, this all-encapsulating notice, giving us the drawings, what it's going to cost, how we're going to actually get to this solution that we want, and we give our members 30 days notice. If during that period a member objects and insists on a meeting, then a members' meeting would be held and a special resolution would have to be obtained. If a member does not exist, and I mean, that's just the polar opposite, the trustees would then proceed with whatever they try and do. Now we're coming to the interesting part. What is not reasonably necessary? Quite an onerous situation, quite an onerous decision that needs to be made. But when one looks at Prescribed Management Rule 29.1, as soon as we're dealing with non-reasonably necessary improvements, one would need a unanimous resolution.
And we know that that is almost impossible to achieve in a scheme.
Absolutely, absolutely.
Oh. Okay, improvements of common property areas. Well, that's what we've dealt with now. Let's deal with improvement of exclusive use areas. So also common property, but where an owner has the exclusive use of that common property.
Yeah, so I think from my side, and I think it's important for everyone to take note that this part of the topic that we're discussing looks at where a specific owner now wants to make improvements. So it's not the body corporate. We as the body corporate decide we want to make an improvement. This is, for example, I've got a garden, an exclusive use garden area in my unit, and I want to now install a jacuzzi or whatever the case I want to try and install. So what is an improvement to an exclusive use area? That's the starting point. I think the starting point before that starting point is what is an exclusive use area. So that is any part of the common property that is now reserved for the exclusive use of a particular member or members, depending on the situation. So now we've got our exclusive use area. We would like to make an improvement to that. So what does the legislation say? I think it's a good starting point to look at Prescribed Management Rule 30G, which says that the body corporate must take all steps to ensure that a member or any other occupier of a section or exclusive use area does not construct or place any structure or building improvement on an exclusive use area, which in practice constitutes a section or an extension of the boundaries. So what a lot of people try and do is they try and say, I'm bringing this improvement to the extent to the exclusive use area, but rather they're actually attempting to extend their own scheme, unit, by doing this. And then a common example of this is enclosure of a common property or exclusive use area balcony, which one can now see that whether or not one would call it an improvement, it's actually an enclosure, which means you're now trying to encroach on the common property or on the exclusive use area. So I know the topic later on deals with these types of things, but let's just look at if it was in actual fact an improvement. So what would one have to do to ensure that we are now entitled to now make this improvement? So firstly, an improvement to an exclusive use area must be the construction or placement of any structure or building improvement. So it's not basically including perhaps a new rose plant. That's not necessarily an improvement. It's actually this structure or building improvement that we're now trying to do. It must not, as I've mentioned, constitute this encroachment of common property or the extension of a section. And then the body corporate must authorize the improvement by way of an ordinary resolution. So if someone wants to approve, it's not the trustees that could say, you know what, I've got a chummy, I'm happy with their LAPA or whatever the case may be. It says by way of an ordinary resolution, which means we'll have to convene a meeting and we'll have to let the members decide what are we going to do. Very important, the body corporate may prescribe reasonable conditions. With any building undertaking, I always advise my clients, it's so important to include conditions. I mean, and there could be a vast number of conditions, but I mean, COCs, those types of things, it's the bare minimum that one must prescribe. I mean, we can't just build something there and there's no structural integrity or there's some other risk. I mean, ultimately, it's still the body corporate's property, the common property or this exclusive use area. And if something may happen there, we must ensure that we are actually now covered with whatever conditions we've prescribed. Another thing could be,
sorry,
yes.
Dylan, if I can just jump in here. If we have a chat about this and we look at, for example, solar panels that are put into an exclusive use area. And let's just use an exclusive use area for this example. A portion of the roof has been now allocated exclusively to an owner. Then one of those conditions would be that the owner must maintain these panels, that the owner will pay for the insurance portion of that panel. So those would be the conditions that you are referring to, that the body corporate must clearly think about and define and put that in place to ensure that the liability does not fall on the scheme as a whole. So that is exactly what you're saying to us now.
Yeah, and for example, a certificate of compliance. We're
Correct.
now installing, we're putting power into the grid. We're dealing with stuff that could possibly kill people. So the bare minimum is that we're actually now doing it in a professional manner, if I can say it like that.
Yeah.
And then also, where there's now the situation of reasonable conditions, we've said we want a COC or whatever the case may be, the body corporate may withdraw any consent if a member or occupier breaches these conditions. So now they're building something, we've told them you can only make a red dog house, for example, and they've now built a braai, and then the body corporate can withdraw this consent, and we can then deal with CSOS or go to the High Court to get orders for them to remove these structures which were now built outside of our reasonable conditions. Then I think a few important things, and I've touched on it a bit. When dealing with these improvements to common property, the body corporate must take the following stuff into account. Firstly, structural integrity. I've mentioned it. We don't want a situation where we've got a roof, we're now giving people consent to now place solar stuff in there, and next week there's a wind and the whole roof has blown off, or the roof falls in, or something like that. So it's always important that the body corporate must consider whether this improvement would actually now impair the structural stability. I mean, the body corporate, in the most rudimentary terms, are obliged to ensure that the structural integrity of the building is intact. So we need to ensure that those types of things happen. I think waterproofing also ties nicely into the solar example. Now we're drilling holes into the roof because we're installing these panels. Did we waterproof it? If the first rain comes, and I mean, we've been blessed a bit with rain here in Midrand at the moment, but what happens if it rains and it's not waterproof? Now we're dealing with a whole other can of worms because we as the body corporate try to be nice. Harmonious appearance. We can't have one house that is red and the rest that are blue, or whatever the case may be. I mean, that's one of the guiding principles why people buy into bodies corporate, is this beautiful facade from the outside. Everyone sees this beautiful scheme. All of the units look alike. We've actually taken the time, the developers now plan this beautiful scheme, and now someone is changing a elevated roof to a flat roof or something like that. So it's very important that there's a harmonious appearance. Always, always, always non-negotiable municipal authority. At any point where any improvement is suggested, I think a body corporate can take a step back and say, well, we want municipal authority if it's required before these things happen. From a scheme rule perspective, the owner who proposes to do the improvement will be bound by the scheme's management or conduct rules or building guidelines. Again, very important part of effective scheme administration is building guidelines. It just makes the whole process seamless. I mean, if we don't have building guidelines and we start prescribing, we want A, B, and C before you build, and then we want C, D, and E whilst you're building, and then F, G, and H after we're building, then we may sit in a situation where we're now accused of being nepotists or whatever the case may be. So it's always important to have building guidelines in our rules so that it's not something that the trustees actually now suck from the fund, but it's something that the members agreed upon. And then building conditions, I've touched on it a bit, but there's a lot of useful conditions that are prescribed, and you guys can go and have a look at these types of conditions. And I mean, it's fit for purpose. So it depends on the type of improvement. That will now depend on how and what type of conditions we would now actually try and impose.
Fantastic, Dylan. Yeah, some of those conditions would be that people can't work, for example, on a Sunday. I know that in schemes in general, there are quiet hours, and you would want people to stick to those quiet hours. And there's building holidays. I know in our scheme, it's an HOA, so not a sectional title, but similar type of rules apply there as well. We, in 2 days' time, will no longer be able to do building work. And we're currently building, so we are in a mad rush to try and finish everything before the building holiday starts. And we won't be able to get people in there any longer. So absolutely right. Extension of sections, also an important thing. We see lots of schemes built many, many years ago. In the interim, I'm thinking of a scheme in Pretoria where there's a garage, and then there's this portion of common property between the garage and the units or the sections. And that has been enclosed by many of the people, and the roof has been put over that. You and I went to a scheme in Amanzimtoti where they have these little courtyards. Many of them enclose those courtyards that you and I have seen, and it's now been incorporated into their sections. So they've extended, for all intents and purposes, their sections, and they now have a larger section, and they're not paying levies for that larger section. So the nicely devised method of collecting levies and determining who's liable for what portion of levies no longer exists, because people have extended their sections by 30, 40, 50 square meters. And some of these were 60 square meters to start off, so they double the size now. So that's a problem. So what would you regard as an extension of a section?
Yeah, so the thing is, and I like to use the words encroachment of the common property. So that's where we now actually take a piece of common property or exclusive use area, and we now build it closed. I mean, there is nice definitions. In terms of the Sectional Titles Act, it means extending the boundaries of the floor area of the section. So that's the legal technical jargon, but ultimately we've got a specific space, and we've now made the space larger in our unit. So I think that would be a good starting point. And again, Willie, I think this all comes down to reasonability. Is it reasonable for your neighbor to have a bigger piece of property? I mean, when they put that property on the market, they're going to get a higher value for that property because of that encroachment. Is it reasonable for us to still pay the same amount of levies? And the answer is simply it cannot be. So that is why this mechanism was created. Yes, we're not saying do not extend. That's not what we're trying to say. But we're saying that when you extend, you are obliged to contribute more than you used to, because you now have a larger space area to deal with, which means your obligation towards the body corporate should also, in effect, increase. So let's look at
you in effect take away from the common property, and owners own the common property to the extent of the percentage that they have as part of the PQ. And by extending onto the common property, you actually also not only encroaching on the common property, but you're actually taking away from their rights in respect of ownership towards that common property.
Absolutely. So yeah, and that's basically why we insist that any of these extensions should be registered, even if it's after the fact. I mean, I'm not saying it's right that one should extend first, but it's also not necessary for each and every scheme to go into litigation to try and break everything down. I mean, if the owners are to an extent happy, let's just get it back on track. Let's just make sure that we sort it out. So how, whether or not we've built or not, how do we now lawfully ensure that this extension is done in terms of the Sectional Title Schemes Management Act? So the starting point would be to look at Section 5(1)(h) of the Sectional Title Schemes Management Act, which says that the body corporate must, an emphasis on must, on an application by an owner and upon special resolution by the owners, approve an extension. So why I emphasize must? The moment that any owner now sends notice that they want to actually extend their scheme, the trustees are obliged to convene a meeting. There's no quorum requirement or something of that nature. It says the body corporate must. So as soon as one of these applications are received, a special general meeting would have to be held. Now that we know we need to obtain a special resolution, it's also important to take note that the more building nitty-gritty requirements of the extensions are found in Section 24 of the Sectional Titles Act, or the old Act, with the extension of sections, and there's various steps. So step 1 would be the land surveyor or architect concerned must submit a draft sectional title plan. I mean, why do we need this? The PQs are increasing, which means the sectional title plan would have to be amended, because I mean, one of the annexures or stuff that is contained in a sectional title plan is the actual PQ calculation sheet. So it's important that a land surveyor or architect would now have to adjust this to include this proposed extension and how it would affect all of the members' PQs. Then the application must also be accompanied by various documents and information to the registrar for the registration of the sectional title plan for the extension. Something that is important to note, that the applicant must, if there's a deviation of more than 10% as a result of the extension. So we've got a 100 square unit. We're trying to now make it 110 squares, 10% deviation. Then we must send notice by registered post to each and every mortgagee, giving important details. So now we have to not only ask the members' consent, but we should also go further and ask the bondholders' consent. And I mean, the reason for it may sound very onerous, but the reason why we're doing this is it actually affects their security. I mean, when they provide bonds, they know that we are the joint owner, or they've got security on a common property, and they've got now security on this person's unit. But now everyone's chopping and changing stuff, which means that the ownership of the common property is reducing and reducing and reducing. So to an extent, the value, and I mean, it's going to be extremely difficult to quantify this, but with owners taking portions of the common property, the actual value of the common property would decrease. And that's why it's important that one should then notify these bondholders if there's a deviation of larger than 10%. Then the registrar shall then register this new sectional title plan of extension, and he shall make an appropriate endorsement. And I mean, we all make this sound very philosophical, but it's basically a stamp that they're also happy with everything. And the copy of the sectional title plan will then be given to the local authority, and they will notify the Surveyor General of the registration of the sectional title plan. And then last step, the Surveyor General will then amend the sectional title plan, i.e. amend the PQ and all of that, and the deeds office copy of the sectional title plan will then reflect this new section.
Then the managing agent has to change the PQ schedule on their software, and from that moment on, levies will change and people will pay in accordance with that. And your insurance premium will probably also change, and you will be charged that additional amount in respect of the insurance.
Absolutely. And again, I think we've touched a bit on why must we actually now ensure that these extensions is authorized. And I mean, we've spoken about an ethical point of view, but there's a wonderful passage here that you guys can also have a look at as to why we want everyone, well, not we, but why the Sectional Title Schemes Management Act actually wants us to ensure that we do these stuff in terms of the Act. And then what process should the body corporate follow to regularize extensions? I mean, this is simply how are we going to make it easier? How are we going to try and help? And I mean, one of my suggestions, I'm not sure if it's in the guide, but do a form. I'm a stickler for forms, anything, but it might be the record keeping component of a form as well. Do a form. Let them complete the form. Let them explain what's going on. Perhaps even if it's a rough draft drawing, so that we can understand what needs to happen, so that the process can start going. But basically, to regularize extensions, what this passage says, that if the body corporate fails to obtain the participation of members in taking necessary resolutions, it will be forced to go to CSOS. So I mean, with any resolution, if there's a failure, there is a mechanism in the CSOS Act where one can now go to CSOS to ask that CSOS actually now substitutes this resolution and gives this authority to the body corporate.
Can I also just jump in here?
Yeah.
That application that one can bring to CSOS in terms of the CSOS legislation, and it's section 38, if I remember correctly. Um, that application can be brought by any affected person.
Yeah.
Would you think that a owner whose neighbor has now extended onto the common property and has extended his section onto the common property and has encroached the common property, as you call it, is an affected person that can now apply to CSOS and say, force the body corporate to regularize this extension that was done by my neighbor. Would that owner be seen as an affected person?
Yes, I would think that it's an affected person. I think my route or suggestion would be that one looks at Section 9 of the Sectional Title Schemes Management Act, where we now actually give the trustees notice. Listen, someone is busy extending. You, as the trustees, have a fiduciary relationship. We're giving you a period to now actually take action on behalf of the body corporate and to ensure that this person gets taken to book. And if you don't do it, we'll do it. So that's my suggestion. It's always, I think, better practice to try and do it from a trustee's perspective. But I would believe that it is an affected owner. I mean, you've got common property, you've got a undivided share in that property, which this person is now encroaching on. So it will definitely affect your rights.
It
And
it also
that's
it
my view.
also it also affects that owner in the sense that that person is paying a larger share of the
Yeah,
budgeted levy
absolutely.
than what that owner in actual fact should pay, because the sections are not, or the levy is not apportioned in accordance with what should be the correct PQ. So
Yeah,
I think we are dealing with ways of alleviating that problem later on in the material. But definitely in my mind, I would think that such a person is definitely affected and can then utilize Section 38 of the CSOS Act or Section 9 of the Sectional Title Schemes Management Act. Definitely, yeah. So
yeah, okay.
Dylan, these schemes where all these encroachments has taken place, you happy to bring those applications in terms of Section 9 on their
Yes.
behalf and do those
No.
applications and take the schemes to task and make sure that they are compliant.
Yeah, I always say, as an attorney, you're not part of the dust of the arena. You're simply a referee holding score and showing people where penalties have happened. And I mean, extending your scheme without authority, that's to my mind a penalty, perhaps a yellow card. I think there is a bit of mitigation. It depends on the situation. Yeah, but maybe even a red card. But that's just a bit of my view. So then, what can the body corporate do to collect the levies on the basis of the correct allocation before the section or sections is or are legally extended? So basically, in layman's terms, I mean, that's beautiful legal jargon. They've now built, and we want them to pay more. What can we do? That's basically the question. So it's unfair that owners must subsidize the levies of other owners who have illegally extended their sections. The process for legalizing the extensions may take some time. I mean, we're dealing with government entities and not just one. So we've got the Surveyor General, we've got the municipality, we've got the Title Deeds Office. So that's a three-peat of what needs to happen.
And you have
But
a body corporate that must make a decision.
yeah,
I mean, as I said earlier on, I was involved in a scheme more than 2 years ago that started with the process to regularize. Is that the right way of saying it? The changes. And still they haven't done so. They've gone through 2 AGMs and still they haven't even moved forward in that regard. So in regard to that specific scheme, I would suggest that legal action be taken by an owner to ensure, because at the moment that owner is paying
yeah.
more than what they should pay. Yeah. But yes, sorry that I interrupted you again.
No worries. So yeah, the two options that we have is changing the effect of the PQ, and as always, going to CSOS. So changing the effect of the PQ. Firstly, the scheme can adopt a rule that changes the effect of the PQ. I mean, we all know levies can be payable per PQ or in equal value, but I mean, we can deal with some interesting rules now as well. In order to modify the PQ, a rule in terms of Section 11.2 will be required to be prepared and approved by special resolution. Why do we say special resolution? The Act says that's why. And then also that further consented to the owners who will be adversely affected. I mean, but to my mind here, if there's an extension and this owner is reluctant, then they might not get the consent of that owner. Because I mean, ultimately, if that owner has to pay more, he will be adversely affected. So we will need his consent as well. Once that has happened, we can then approve our rules of CSOS. So that's one of the options. But again, this would mean that that owner who made the extensions is actually on board for this change in PQ, because if it's not, then you'll not get his consent to my mind. Then having the levies adjusted at CSOS. So in terms of 39(1)(c) of the CSOS Act, an application made in terms of Section 38 must include one or more of the following orders. And then in respect of financial issues, an order declaring that a contribution levied on owners or occupiers or the way it is to be paid is incorrectly determined and unreasonable, and an order for the adjustment of the contribution to correct or a reasonable amount, or an order for its payment in a different way. So then the CSOS Act also now provides a vehicle where we can go to CSOS, say, listen, these extensions, we don't want to deal with the legality of that. We're busy with the legality of that. But in the interim, we've got the situation. This owner is now unfairly prejudicing the rest of the scheme or members, because they are now having to subsidize his part of the levy. I mean, he should pay more, he or she should pay more because of this extension. So we're going to CSOS for an order. So those are the two options in the interim whilst we're now waiting for this extension to be finalized. Then increasing the insurance. The legal extension could also require the scheme's insurance coverage to be increased, as there is now additional common property. I mean, they're extending this unit, they're placing a roof where this unit is, and we all know that the outside of the building is the responsibility of the body corporate, which means now this additional roof is now our problem again, which means that this would then result in us having to change our insurance values. All right. So yeah,
Dylan, can
that's
I jump in here again? I mean, we're going to now discuss change of use as well. So I think you and I have seen that in many instances where garages have been changed to granny flats. I think that's the example that we're using in the material as well. Or we have seen that a patio is being enclosed, and that patio might have been a part of the section, and it's now being enclosed, and it's now being used for a bedroom or a bathroom or something to that effect. So the use of that portion is completely changed. So let's have a look at what does constitute a change of use. I think garages is a simple one. We know that there's a big garage door and there's a driveway in front of it. So we know that that is being used to store a vehicle. But we see in general that people now want to use it as a workspace, want to put tools in there, want to work from home, want to fix cars in the garage. So it becomes a business. So maybe you can take us through the change of use.
Yeah, perfect. So yeah, and I mean, you've touched on the granny flat. Another common example would be I've got this residential place, but now I want to start a law practice there and turn it into a business. Or I see this is quite outlandish, but we've got a balcony and we're turning it into a bathroom. Good luck for the neighbors looking out on your balcony. It might be a sight for sore eyes. But yeah, so it's basically when one now changes the whatever the intention was with that particular space or unit or whatever the case may be, we've now changed it into something else. So
Can I jump in? Can I jump in here? The first deal that we ever did at Stratafin was in a complex in Witbank. And when Sava, my partner, and I, business partner, and I went to the complex, we found one of the units, a bottom floor unit, and it was changed to a funeral parlor. It actually had big ice boxes in there, and there was, in actual fact, bodies being stored in this residential complex. So we're at the front of our lives. So one can have some serious change of use issues in some schemes.
Yeah. No, I think it may be the mentality that it's my property, so I can do what I want. And I think that's the unfortunate where egos start to clash in community schemes. I mean, there is a Latin saying, and I don't know the exact Latin. First time an attorney tells you there's a Latin saying and he doesn't know the Latin, but it says that the mother of all problems started with communal ownership of property. So, and one can see it with all of the interesting, to say the least, situations that schemes have been faced. So what does the legislation say about change of use? So section 13(1)(g) is where we start. And it says an owner must, when the purpose for which a section or exclusive use area is intended to be used is shown expressly or by implication on the registered sectional title plan, it depends on the situation, not use or permit such section or EUA to be used for any other purpose, provided that with written consent of all members, and this is one of those pickles. I mean, we've discussed all of these different consent levels, but this is now the holy grail of consent, which is written consent of all owners. So not
This
even
is not
unanimous.
this is not even a unanimous resolution. That's what I wanted
Yeah.
to jump in. This is all owners, 100% of them, not 80% and 100% of the 80%, 100%.
Yeah. This is the unicorn consent. If you guys find the unicorn or the unicorn scheme which actually gives this, please tell us. We want to study the people's heads to see how all of them can agree. Maybe that would solve the world's problems, to try and find out how every single person can agree in a scheme. So yeah, but that's the requirement for change of use. Everyone needs to be notified of what's going on. My assumption would be that full particulars would have to be given. We're now trying to change our granny flat or our balcony into a bathroom. Type of things that we would need to know is when they would go to shower, will the blinds be open or not, those types of things, so that we can ensure whether or not we would be giving written consent. And then one also needs to look at section 13(2), which says any owner who is of the opinion that any refusal of consent of another owner in terms of the proviso to section 3(1) of 13(1)(g) is unfairly prejudicial, unjust, or inequitable, may within 6 weeks of such a refusal go to CSOS. So if you are of the view that you want that bathroom and the people are simply being unreasonable, then one can go to the Ombud to ensure whether, or for them to determine whether it's reasonable or not. Another important thing to consider is prescribed management rule 30F, which says that the body corporate must take all reasonable steps to ensure that a member or any occupier of a section or exclusive use area does not, subject to the provision of 13(1)(g), i.e. written consent of all members, use a section or exclusive use area for any other purpose than its intended purpose. So there we can see that there's this obligation on trustees. It's not just whether or not they want to do it or not. There's actually an obligation on trustees to ensure that this change of use does not occur unless there is compliance with section 13(1)(g). There's a bit of case studies for you guys. What I can say is next week, Monday, we'll have a closed book test for you guys. So please make sure that you read through all of these cases, very interesting matters. And one can see, as I said, the mother of all problems started with communal ownership of property. But yeah, I think just to close this out, you cannot change your use of your section without written permission of all members. And where this happens, the trustees are actually obliged to ensure that this doesn't happen. So how can we now prevent this? I mean, the guy's now saying we're changing our garage into a granny flat, and we're saying, no, you didn't. What do? We need to go to court or to CSOS to get an interdict to ensure that whatever is happening does not happen in the future. So that's what needs to happen.
Then, Dylan, in the notes, we've spoken about enclosing of balconies. I think that is just the principles that we have
Yeah.
now discussed. So definitely that is on Sectional Title Living South Africa, the Facebook group where we try and answer questions and try and help people to run their schemes compliantly. We get a lot about balconies, so have a look at that, guys. We discussed that in detail there. You need to know if the balcony was part of a section, is it part of common property, or is it an exclusive use areas. So all three those things are dealt with differently. So have a look at that. It is in the notes. I think Dylan has explained it sufficiently, and what the consequences are of change of use in respect of those things. Then I think what is also important is water meters, electricity meters, prepaid water, postpaid water meters. Dylan, if you can maybe take us through that. I think we're running a bit out of time, so that's why I am jumping a bit forward, but let's quickly have a look at separate water and electricity meters.
Yeah, so I mean, in the conventional sectional title scheme sphere, we've got a few variants when dealing with water meters and all of this. The first variant would be that there's a bulk water meter outside. COJ takes a reading and it sends the body corporate the bill, and we then allocate it to everyone. But I mean, now we're sitting with situations where we've got Tanisari at Unit 3 that says, well, I can see Unit 6 is constantly leaving the TV on, so why should I pay the same as they are paying? And then we're sitting with this conundrum about separate water or electricity meters. The most important to me is whenever dealing with this issue, start with Prescribed Management Rule 29.3, which says a body corporate must, if so directed by a resolution of the members, install and maintain a separate meter to supply electricity, water, gas, or supply any other service to each member section or exclusive use area, and to recover from the members' costs of such applies to the sections and exclusive use areas.
I think in practice, we find that water is the big culprit here. Normally, schemes don't have separate water meters, and the water is then apportioned by PQ to all owners of schemes, of sections. And some sections have one person living in there, and others have 10 people living in there, and that is where the unfairness comes from. And as Dylan just said, if owners direct, so then the scheme must install these meters. Thanks, Dylan. Those would be postpaid meters.
Yeah, and then we also have prepaid meters or prepayment meters. It's the first time I've heard of prepayment, but I assume prepaid is just the jargon that us youth like to use. But yeah, then we're looking at Prescribed Management Rule 29.4, which says on the authority of a special resolution. So there, again, a different requirement. And then this is also one of those exceptional circumstances where the normal rules of the game for special resolutions are a bit changed. And this is simply that 60 days notice should be given. So not the conventional 30 days. Please don't fall short of this. Make sure that 60 days notice is given for this resolution. And again, it's always important, and Prescribed Management Rule 29 didn't even have to say it, but we need to provide anyone with all of the relevant information when we give them notice. It's all good and well. We've got this one-liner notice of a meeting. We want to install prepaid meters, but I mean, this raises a lot of questions. How are we going to do it? When are we going to do it? What is it going to cost us? So all of those things, it's to my mind, principles of good governance would suggest that one provides the members with all of the information that they need to take an informed decision.
I was blown away today by a scheme that's installing prepaid water and electricity meters, and it is now suddenly a requirement. And going through the AGM minutes, there was no requirement of owners paying a deposit. And now it is a requirement that owners must pay a deposit in respect of prepaid water and electricity meters. the mind boggles why one would have to pay a deposit in respect of those, because if it's prepaid, you pay for your usage. So if you haven't used it, or if you've used it and you haven't bought more, then you can't use. So there's no reason why there should ever be a deposit. And suddenly this vendor now requires the payment of deposits, and people have been disconnected because they didn't pay deposits. So like Dylan says, know what the whole thing is, because you can't make a decision on something that you don't know all the circumstances surrounding it. And one would in general be able to attack that decision on the basis that the information was not supplied. Thanks, Dylan.
No, absolutely. And again, I just also wanted to say that this is a product of not making an informed decision. I mean, where was okay, what is it going to cost us question? When was that asked? Are there deposits? Are there hidden fees? I mean, if one goes to the bank and you want a bond, one takes the time to read the terms and conditions because it's important, because it actually has a material bearing on what you're trying to do. But this is sometimes I get the feeling that trustees rush into decisions. Yes, we want this. We're pushing this agenda that we need this, and then we make rash and ill-conceived, not well-considered decisions. So that's why it's important that the questions get asked. And normally, when questions are asked, these types of things would come out, and then it would have been a more informed decision. And then also just touching on Prescribed Management Rule 29.5, if such a prepaid system is installed, we need to ensure that and understand as well, the body corporate is responsible to ensure that the system does not infringe on constitutional rights of section occupiers to access to basic services. Yes, I've heard the argument so many times. Let's load those levies onto that prepaid meter. Well, it may result in spoliation. So my situation is always, when we're trying to do these things, I mean, we don't have Prescribed Management Rule 45, which says you are entitled, if there's prepaid meters, to add levies. So where are we getting this right from? Where are we saying we are entitled to do this? There is no provision for that. So we need to go to court and actually get an order to that effect, and then we can start doing these things. Because if we don't, then we're sitting perhaps with a breach of a fiduciary duty here. We were responsible to ensure that the system does not infringe our constitutional rights. I went hunting this year. I've got this big freezer full of meat. They've now tried to do this levy stunt. I've incurred damages. Now who's responsible? I mean, yeah, it says the body corporate is responsible. So that it starts asking a lot of questions. And I think it's important for trustees to note that this could result in a possible liability if we start doing these types of things. And then also just from a tenant, I mean, it says the same thing, just in the perspective of a tenant, does not infringe on the tenant's rights in terms of the Rental Housing Act, which again tracks back to access to basic services. So whether or not you're an owner or tenant, you are entitled to these basic services. So before we start making these creative collection decisions, and I'm saying it's creative because it is very creative, just make sure that we do it on the right manner.
I can just jump in here. Sorry, Dylan. There's many schemes that are placed under administration where the prepaid meter is used as a methodology to collect arrears on municipal charges, on monies outstanding to the scheme. But those are all done in terms of court orders. So you would know because you draft those applications, and that is part of the application that where a court is required to grant an order to that effect. And the court then considers all these infringements on the rights of owners before it actually grants that order. But you can't just contractually now put those things in there and not tell people that you are going to do that, and then at the end of the day just apply it. And we see that with so many electricity suppliers or prepaid electricity suppliers, that they do these things, and then they say contractually they are entitled to do so. But you can't also contractually agree yourself out of the Constitution of South Africa.
Absolutely.
I mean, so that would be regarded as pro non scripto. So a court will not even look at those conditions and say, but this infringes on your basic human rights. And you can't contract out of that. So people must be very careful not to just throw those things in there and think that that can happen like that. It's not as simple as that.
Absolutely. Yeah, and I think that does it for prepaid meters. There is a very nice summary where there's a bit of a point-to-point situation where they're saying how we propose to do it. So go and have a look at that and see if you guys have done this prepaid meter, how far it aligned with what Strathofen and the industry experts are suggesting. I mean, this is an important yardstick. I think any person thinking about undertaking this situation, look at these step-by-step analysis and try and align with that. I mean, the experts, we're not saying this to be difficult. We're saying this because that's how it should be done. Otherwise, we may have to settle this whole issue in court, which is not always the best forum to now try and finalize our decisions.
I think the last thing that we do discuss in this module is solar panels. Dylan, you and I have been part of many panels where we have discussed solar. And what I'm going to do is I will also include links to those webinars and those discussions, panel discussions that we had before, so that people can also look at that, because I think there are very, very prudent and important facts that come out of those discussions from all different types of industry experts, insurance experts, solar experts, legal experts. I mean, we've got Richard Brits, Dr. Richard Brits, Dr. Karen Durham, Zerlinda van der Merwe. So we've got many, many people that have given their proper opinions. And we see on sectional title living that lots of people say, no, just go ahead and do these things. And I think it's important for schemes to actually look at these webinars and understand that we're not saying you shouldn't have solar. We're just saying do it in a compliant manner. And I think we ran out of time, so that's why I just want to finish with that, saying that we will also put those links in there so that you guys can actually have a look at those as well and get a great idea. But we hope that you're going to enjoy this specific module, topic 10, the physical management, part 2. Trust that this is going to help you manage your schemes in a better manner. Thanks, Dylan. Really appreciate your assistance today.
Thank you very much, Billy. And to all of the readers, don't forget on Monday, we've got an unprepared class test. So be sure to take your notes and to peruse it properly. I think there's a lot of effort that Strathofen and the industry places into educating the trustees. And I think it's a wonderful platform. So I just want to say thank you from our side to these wonderful companies who actually now take the time to educate everyone. So thank you very much, Billy.
Thank you so much, Dylan from DTB Attorneys.